I rise to speak to Bill C-45 in relation to international conventions. Before I address Bill C-45 directly, I think it is important that we all note how important Canada's international reputation is. It has been fought for in war and in peace, step by step, inch by inch, and it is one that others marvel at and have pride in. And therefore, any time that it is being questioned, I think it deserves to be repeated over and over again why international relations and why our international commitments are important. And in that context, I want to speak to Bill C-45. The government's approach to the legalization of recreational cannabis has been clouded with uncertainty. Bill C-45, with respect to Canada's international obligations, is no exception. All witnesses advised the Standing Senate Committee on Foreign Affairs and International Trade that Bill C-45 places Canada in violation of the provisions of 3 international drug treaties. I won't enumerate them. Senator Bovey has done an adequate job in that. Throughout decades, Canadian governments, organizations, and citizens have been leaders in promoting international conventions, treaties, and agreements as the best avenue on many issues that demand universal cooperation and adherence. Drug policies are a prime example. The 3 major conventions are a result of long negotiations to a changing and often criminal scene in the use, sale, and transboundary activity of illicit substances. Any reasonable response was deemed to need an international response. In his appearance before the committee, Professor Dwight Newman, Professor and Canada Research Chair, College of Law, University of Saskatchewan, stated, and I quote, "Large-scale renegotiation would be a long-term project and in many ways not feasible," end of quote. As such, it appears it is too late to turn back now. The fact is, Bill C-45 will place Canada in violation of these 3 conventions. We lose the moral as well as the legal ground in calling out their violations. Sorry. I think it's the dampness here as opposed to Saskatchewan. The International Narcotics Control Board, the body tasked with monitoring adherence to the UN Drug Control Conventions, indicated in its submission to the committee that Bill C-45 is, and I quote, "incompatible with the treaty obligations to which Canada is bound," end of quote. In this respect, witnesses before the committee provided varying options for Canada. Many indicated that withdrawal from the conventions would have required earlier action on the part of the government. Other suggestions included the declassification of cannabis or readherence under a reservation. Finally, others felt that strict compliance with the conventions is necessary. Witnesses also discussed a shift taking place globally with respect to international drug control and the non-medical use of cannabis. I would note, however, that this shift has only taken root in certain parts of the world by certain advocates. While some countries have looked domestically at decriminalization of cannabis, there has been no outright violation of the drug control conventions. The most notable exception is Uruguay. Although the breadth of their legalization is worth looking into, it is not as far-reaching as Canada's. While Uruguay remains a signatory to the conventions in spite of the country's decision to legalize the non-medical use of cannabis, we are not privy to the internal discussions between Uruguay and other international partners. It would be therefore premature to use Uruguay as an example for Canada either way. Despite receiving testimony from officials at Global Affairs that violations represent, and I quote, a technical breach, the Minister of Foreign Affairs, Chrystia Freeland, stated in her appearance before the committee, and I quote, "The issue of the conventions is an important one, and the government needs to be clear about it," end of quote. While acknowledging the violation, the minister stated that the government believes that Bill C-45 is consistent with the overarching goals of the conventions. When asked about the government's approach to the violations, the minister continued, and I quote, "The government is open to working with treaty parties to identify solutions that accommodate different approaches to cannabis within the international framework." While indicating that a direct withdrawal from the conventions will not be undertaken, the minister was unable to provide any clarity to the committee regarding the government's plan. The fact that Canada has been elected to the Narcotics Control Commission should not be taken again either for or against any position. It is too early to say, and we all know, those of us who worked in the international field, what negotiations are like, and surprise, surprise, who ends up on which board or which commission. It is therefore worrisome and I think troubling that Canada, as a leader in promoting international conventions and the rule of law, has no firm plan. It is discouraging that no information has been disseminated to parliamentarians or to Canadians with respect to the government's specific intentions. I would like to highlight one instance in Canadian history which sets a precedent. And this is a very far and few precedents that we could find, and it is the adoption of the Arctic Waters Pollution Prevention Act. Canada violated the law of the sea and the Geneva Conventions on the Law of the Sea. In his appearance before the committee, Armand de Mestral, professor, Faculty of Law, McGill University, described the government's approach to remedying this violation. He stated, and I quote, "The Canadian government at that point in 1970, having legislated in a way which clearly was seen as interfering, not violating, but interfering with international shipping, but where we deemed it absolutely imperative that we do so to protect the Arctic and the waters and the environment of the Arctic, took a reservation to the jurisdiction of the International Court of Justice on matters pertaining to pollution prevention." He goes on to say, "We built a consensus. The Third Convention on the Law of the Sea gave us a platform where we were able to make our argument successfully that change was needed. In this particular instance, Canada took no forward action or plan in advance. With respect to Bill C-45, we will be breaching the international conventions without real knowledge or understanding of the implementation of the bill. Too often we have heard there will be education, there will be implementation, there will be data, but we do not have a concrete plan, such as we had in the Law of the Sea. Honourable Senators, a breach of international conventions carries with it significant political ramifications for Canada and the international community, and I underscore, and the international community as a whole. In his appearance before the committee, Professor Steve Hoffman, Faculty of Health at Osgoode Law School, York University, stated, "The practice of international law is the collection of micro-decisions that take place every day in rooms like this, committees like yours, and by people like you who are deciding every day whether international law matters enough for it to be adhered to or whether it doesn't." End of quote. Colleagues, in my opinion, international law must matter. A basic principle of international treaty law, pacta sunt servanda, means that treaty obligations must be obeyed. We made a commitment to abide by the provisions of these agreements, and we therefore cannot be selective in our adherence. In his testimony before the committee, Mr. Paul Larkin, Senior Legal Research Fellow, Meese Centre for Legal and Judicial Studies, stated, and I quote, "There is a risk that the passage of Bill C-45 could adversely affect the judgment of the world community regarding the reliability of Canada as a partner to international conventions. Moreover, I state international treaties and agreements play a critical role because they maintain order and stability in our very fragile world. The direct violation of Canada's treaty obligations sets dangerous precedences in already a fragile and increasingly fractured world. The timing could not be worse. In fact, it is curious to note that we have been consistent in approaching China about the increased opioids coming from China to Canada. It is interesting that after Bill C-45 was in Parliament, China is now calling on Canada, expressing concern about illegal marijuana going to China. This is the kind of issue that troubles me because it is just the start of an unraveling that took decades to build. In my view, an outright violation of drug control conventions will signal to international actors that breaches of international law and agreements are acceptable. We are already witnessing international actors taking destabilizing actions in defense of their so-called national interests. And that is what our minister said was our national interest as to violation. Well, we can just count the number of times the not-so-friendly countries that we deal with say in national interests they violate conventions. Honourable Senators, we are placing our international reputation at risk.
Expired.
Thank you.
Senatrice Belmar.
Chers collègues, je propose la journée.
Dear colleagues, I move that the debate do now adjourn. The Honourable Senator Bellemare moves, seconded by the Honourable Senator Petitclerc, that a debate be adjourned until the next sitting of the Senate. Is it your pleasure, Honourable Senators, to adopt the motion? Carried.
Bills, reports of committees, projet de loi, rapport des comités. Number 1, 24th report, legal. Bills.
Stand.
Bills, second reading, projet de loi, deuxième lecture. Numéro 1, C-48.
Number 1, C-48.
Number 2, C-55.
Rapporteur.
Numéro 3, C-5.
Number 3, C-58.
Stand.
Number 4, C-65.
Stand.
Reports of committees other, rapport de comité autres. Number 12, 18th report, foreign affairs.
Stand.
Numéro 13, premier rapport.
Number 13, first report, Arctic.
Agriculture.
Senator Griffin.
Honourable Senators, last week I tabled the Standing Senate Agriculture and Forestry Committee's pre-study report on Part 5 of Bill C-47 as it relates to farming. This is part of the Budget Implementation Act that enacts the Greenhouse Gas Pollution Pricing Act, which creates the federal backstop carbon levy. The committee heard from farmers who made 3 technical recommendations that directly relate to C-74. If government acts on these technical recommendations by farmers, it will ensure that the financial impact of the carbon levy does not burden specific classes of farmers. Whether you grow chickens in Manitoba, operate a greenhouse in Saskatchewan, or harvest New Brunswick maple syrup or Christmas trees, all farmers where the federal backstop could apply must be treated equally. The Senate's National Finance Committee could amend C-74 and seek clarification from government on the definition of farming. I would like to highlight 3 technical recommendations from farmers, 2 changes or clarifications to C-74 that would ease the financial cost of the carbon levy for farmers. First, exempt heating and cooling fuel costs related to farming from the carbon pricing levy in the Greenhouse Gas Pollution Pricing Act. Second, specifically include propane and natural gas under the definition of a qualifying farm fuel in the Greenhouse Gas Pollution Pricing Act to exempt those fuels from the carbon pricing levy. And 3, ensure that the definition of farming in the Greenhouse Gas Pollution Pricing Act is consistent with the Income Tax Act and also the Canada Revenue Agency's ordinary definition of farming activities. Senators, I agree with these three sensible suggestions by farmers. The Canadian Federation of Agriculture, the Canadian Horticultural Council, and the Canadian Produce Marketing Association also support these suggestions. Our committee received a brief from the Chicken Farmers of Canada highlighting the need to amend Bill C-44 to exempt heating and cooling fuel costs for eligible farming machinery from the carbon levy. Currently, the Act specifies the carbon levy, or applies the carbon levy to eligible farming machinery used for heating and cooling. The chicken farmers noted that I'm being distracted here. There's several conversations on the go. I'm sorry. Currently, the Act specifically applies the carbon levy to...
Excuse me, Senator Griffin. Excuse me for a moment. You're quite right to point out that there are a number of distractions. Please, Honourable Senator. Senator Griffin has the floor, and if there's something you wish to discuss, please take it outside. Senator Griffin.
Thank you, Your Honour. The chicken farmers noted that using, quote, by the way, using natural gas, propane, or other fuels is critical for maintaining proper temperature and humidity levels in the barns for optimal bird comfort, end of quote. They argued that the levy could, quote, unfairly burden farmers who are committed to doing the right thing when it comes to animal care and the environment, end of quote. I urge the Senate's National Finance Committee to act upon farmers' request to amend C-74 to include propane and natural gas under the definition of a qualifying farm fuel in the Greenhouse Gas Pollution Pricing Act, to exempt those fuels from the carbon pricing levy. As we heard from Mr. Ron Bonnet, the president of the Canadian Federation of Agriculture, quote, natural gas and propane play a very important role in production, for example, in grain drying to maintain quality and avoid spoilage prior to marketing, and in the greenhouse sector, which is a large user of natural gas for both heat and as a pure source of CO2 to promote plant growth within the controlled atmosphere of the greenhouse. It is the Canadian Federation of Agriculture's position that all on-farm fuels be exempt from carbon pricing, end of quote. In a brief to the committee, the Quebec Union des Producteurs Agricoles reiterated this point, quote, the definitions of qualifying farming fuel and eligible farming machinery mean that certain fuels, such as propane and natural gas, and the use of fossil fuels to run certain machinery for heating and cooling buildings, would be ineligible for potential exemption from the charge. This is also a matter of equity among farmers, since this equipment can be just as critical to certain farming sectors as the machinery and fuel used for field work. The UPA recommends revising these definitions in order to broaden the definition of qualifying farming fuel and eligible farming machinery to include all fuel and machinery used for farming operation needs, end of quote. The third observation I would like to highlight today is to ensure that the definition of farming in the Greenhouse Gas Pollution Pricing Act is consistent with the Income Tax Act and also the Canada Revenue Agency's ordinary definition of farming activities. We heard this again and again in our committee. For instance, Mr. Chris Van den Heuvel, past president of the Nova Scotia Federation of Agriculture, told us, and I quote, the definition of a farmer used within the draft legislation is seen as overly simplistic and could inadvertently disqualify legitimate farmers from receiving carbon price exemption charges on farm fuels. In reading the proposed definition, it would seem to exclude agricultural activities such as Christmas tree farming, greenhouses, maple syrup production, aquaculture, and others. Although the legislative definition is the same for the Income Tax Act and Bill C-74, the Canada Revenue Agency issues interpretation guidelines that expand the definition. Senators, the solution in this case is not legislation, but communication. All that the government needs to do is to state that when Bill C-74 comes into force, that they intend to apply the CRA's ordinary definition of farming in the Greenhouse Gas Pollution Pricing Act. The Nova Scotia Federation of Agriculture observed, and I quote, "This will provide far greater consistency across the government on what constitutes farming and will be easier to interpret for all." End of quote. On this point, I am hopeful. Last Tuesday, I made the request to the Minister of Agriculture and Agri-Foods during question period, and he seemed quite open to ensuring that the two definitions correspond. Mr. Macaulay said, and I quote, "I will make sure that the Canada Revenue Agency is aware of what you propose, and if those changes can be made, and if it helps people involved in agriculture, that's certainly the way to go." End of quote. Members of the Senate National Finance Committee, the Minister of Finance will be appearing tomorrow at your committee meeting. I hope that you raise these three concerns from farmers with him during your meeting. Due to logistical and scheduling issues, farmers were unable to raise these issues in the House of Commons National Finance Committee. I'm grateful that government agreed that the Senate Agriculture and Forestry Committee study the impact of the carbon levy on farmers. Senators, farmers across the country took the time out of their planting season to speak to the Agriculture and Forestry Committee. The committee listened. Now is the time for the Senate's National Finance Committee and the Senate to act. Thank you.
Senator Wu. Going to take a question, Senator Griffin?
Yes.
Thank you, Senator Griffin, for presenting the report of the Agriculture and Forestry Committee on behalf of the other members, of which I am one. I wonder if you might just clarify with the Chamber that under the Climate Action Framework, provinces are, of course, strongly encouraged to come up with their own climate action plans, which include the possibility of defining on-farm fuels and the extent of the exemptions that they wish to make. Also, that they have the flexibility and the power to use revenues generated from carbon pricing to reinvest in farming activities, and that therefore we heard in testimony, in fact, that many of these issues, while subject to some federal guidelines, are very much in the power of the provinces to put in place.
Senator Griffin.
Okay, there's a lot in that. Thank you for the questions. Okay, the situation is that it's different in different provinces. Some provinces already have a cap and trade system or their own carbon pricing system. Others do not, and of course that's where the federal backstop will come in. So that's where the definition in this act, or these acts, is going to be really important to provinces like Prince Edward Island, Saskatchewan, and the others, I think New Brunswick, that will have to have the federal backstop because they are not doing their own carbon pricing. So that's one issue. So it is different in different provinces. And regarding reinvestment, yes, the provinces who do have their systems in place can easily reinvest it in agriculture. And Alberta has a wonderful system of paying farmers for carbon sequestration. We heard that loud and clear when our committee was out west. So, but it is uneven because not all provinces are doing the same thing, unfortunately. Maybe someday they will be. But in the meantime, we're pointing out that this is an issue that for the federal legislation needs to be considered. Thank you.
Senator Duffy, question?
Senator Griffin, did I understand you to say that there are different definitions about the treatment of fuels on farms compared to other industries? And if that's the case, do you foresee a situation in which people will be going to court, maybe the tax court, to appeal for equal treatment rather than have various industries treated differently under the same regime?
Senator Griffin.
Well, that's some interesting thoughts. There are different definitions in the provincial legislation as to which fuels are included. In many cases, the natural gas and propane used on farm for farm-related purposes are included, but it is not included in the federal legislation. So that's where the issue comes for provinces like Prince Edward Island, New Brunswick. Going to court, well, that's anybody's guess. Thank you.
Honourable Senators, if no other senator wishes to speak, this order is considered debated. Senator Joyal.
Honourable Senators, I seek your concurrence to revert back on the orders of the day to bills, reports of committees.
Leave granted, Honourable Senators. Agreed.
Adoption of the report.
It's moved by the Honourable Senator Joyal, seconded by the Honourable Senator Day, that this report be adopted. On debate, Senator Joyal.
Honourable Senators, I would want to draw your attention to the work of the Legal and Constitutional Affairs Committee in relation to Bill C-46. The Legal and Constitutional Affairs Committee held 13 meetings on this bill between January 31st and May 23rd. We spent almost 5 months studying this bill. The committee heard from a total of 68 witnesses. I want to draw your attention on this because it's certainly, and with all due respect to the Social Affairs Committee and all the other committees that were charged to study some aspect of Bill C-45, that in fact the Legal and Constitutional Affairs Committee was the committee that heard the largest cross-section of witnesses in relation to cannabis generally, of course, within the confine of C-46, which is essentially, as you certainly know, an act that deals with drug-impaired driving. We receive also a very large number of written briefs. 7 amendments to the bill were adopted on a total of 14 amendments proposed during the committee clause-by-clause consideration of the bill. And I want to list to you those 7 amendments in a very short way. The first one add to the preamble that the Parliament of Canada is committed to, and I quote, adopting a precautionary approach in relation to driving and the consumption of drugs. The second amendment removed proposed section 320.27 of the Criminal Code, which would have authorized mandatory alcohol screening to the bill. The third amendment add to propose section 320.314 of the Criminal Code concerning the legal presumption for alcohol by specifying that the presumption applies with regard to the person's blood alcohol concentration within 2 hours after the person ceased to operate the conveyance, and by specifying that the addition of 5 milligrams of alcohol in 100 millimeter of blood for every interval of 30 minutes in excess of those 2 hours only applies when the person's blood alcohol concentration is equal to or exceeds 20 milligrams of alcohol in 100 millimeter of blood. The Fourth Amendment specified at proposed section 320.319 of the Criminal Code that a statement made to a peace officer is admissible in evidence for the purpose of justifying a demand made under section 320.27 and section 320.28. The Sixth Amendment specifies at proposed section 320.34 of the Criminal Code concerning the disclosure of information by the prosecutor with regard to messages produced by the approved instrument that only error or exception messages must be disclosed. The Seventh Amendment specifies at clause 31.1 that the review of the bill that must be done within 3 years must include an evaluation on whether their implementation and operation have resulted in differential treatment of any particular group based on a prohibited ground of discrimination. And finally, specify at clause 38 that any person designated as an analyst will keep their designation when Part 2 of the bill comes into force. Honorable Senators, in annex to the report, you will find a summary of all the testimony that was heard in a summary fashion. And I invite you to read those 10 pages because they summarize really the bulk of the testimonies that we have heard. And again, I mention, Honorable Senators, that it includes the testimony of more than 68 witnesses in a period of 26 hours of testifying. I don't want to qualify more the work of the committee. I think each and every one of you can understand the work that has been achieved by the committee members, and I am very grateful to the members on both sides of the table at the Legal and Constitutional Affairs for the cooperation and dedication to that work, which I think will remain a very important element of information for the interpretation, of course, of this bill by all the stakeholders who have an interest, of course, in drug-impaired driving. I want also to add that there was an observation in the bill, in the report, that deals essentially with and I want to be very specific on this, that permanent residents and foreign nationals would be deemed inadmissible to Canada because of the charge that he would face under drug-impaired driving would be treated in a way that deals with their status. And I think that there is an amendment in relation to C-45 that I've noticed in the report of Senator, our colleague Senator Eggleton, the chair of the Social Affairs Committee, that deals with that specific observation. And I'm grateful to the Social Affairs Committee to have reflected the concern we have had in relation to C-46. So, Honorable Senators, I submit that for your consideration. I know that this chamber will certainly want to organize the debate in relation to this bill in a structured manner so that those of you who are interested to take any part of the discussion of the amendments of this bill will have an opportunity to do so, and that we could send that bill, of course, in the other place for due consideration. Thank you, Honorable Senators, for your attention. Merci bien.
Senator Batters, on debate?
Yes, on debate. Honorable Senators, I rise today to speak to the 23rd report of the Senate Legal and Constitutional Affairs Committee on Bill C-46, the Trudeau government's impaired driving legislation. I am a member of the Senate Legal Committee and have been for the past 5 years. In that time, the Legal Committee has devoted significant time to studying the problem of impaired driving, particularly as it relates to the critical problem of significant court delays. We also studied various legislative initiatives seeking to reduce the frequency of impaired driving, both for drug and alcohol impaired driving. The impaired driving legislation currently before this chamber, Bill C-46, addresses both drug-impaired and alcohol-impaired driving. It was introduced in the House of Commons as a piece of companion legislation to the marijuana legalization legislation, Bill C-45. Perhaps a more cynical person might even suggest that Bill C-46 was created to provide some political cover for the government's untested drug legalization measures in Bill C-45. The first part of Bill C-46 creates drug-impaired driving offences and a regime for roadside testing of drivers based on a reasonable suspicion of impairment, much as alcohol impairment measures in place currently. The second part of the bill addresses measures concerning alcohol-impaired driving. Most notably, Bill C-46 proposes mandatory or random alcohol testing, which would mean that police would no longer have to have a reasonable suspicion of alcohol impairment in order to ask a driver for a breath sample. As many of you will know, I proposed an amendment at our legal committee to delete the random alcohol testing provisions of this bill, and that amendment, passed by a majority of committee members, is contained in this report, as our chair just told you. We heard a mountain of evidence from legal experts at committee that this random alcohol testing regime is unconstitutional. In fact, in my 5 years on the committee, I've never before heard legislation so roundly denounced as unconstitutional. The vast majority of experienced criminal lawyers who appeared before our committee expressed grave concerns about the charter implications of this provision. Witnesses told us that Bill C-46, and in particular the random alcohol testing measures, could be found to violate the Charter of Rights, Section 8, unreasonable search and seizure, Section 9, arbitrary detention, and Section 10B, the right to counsel. Adam Stephen Boney of the Canadian Council of Criminal Defence Lawyers told us that, quote, all of the charter nerves have been set tingling by this proposed legislation, quote. One very experienced criminal defense lawyer testified that random alcohol testing would lead to a decade of charter litigation. Another said that if these random alcohol testing measures passed, it would be Christmas for defense lawyers. Virtually every lawyer and legal expert who came before our committee found random alcohol testing to be unconstitutional. One exception was law professor Peter Hogg, who argued that Section 8 challenges of random alcohol testing would be saved by Section 1. Unfortunately, Mr. Hogg didn't appear before the Legal Affairs Committee, but instead submitted a copy of the written brief he had prepared for the House of Commons on the topic last year, meaning senators did not have a chance to question and challenge his assertions. Professor Hogg drew from Robert Solomon's evaluation of random alcohol testing in countries like Australia and New Zealand, countries that don't have a Charter of Rights and Freedoms. But renowned legal professor Don Stewart, the person who literally wrote the textbook on charter rights and criminal law, effectively refuted Hogg's claim. He said that in 35 years of charter challenges under Section 8, the Supreme Court has never justified a Section 8 charter challenge under Section 1. Lawyer Kyla Lee, herself an expert in impaired driving cases, delivered a compelling argument to us that Canadian cases about roadside testing and approved screening device testing that had been saved under Section 1 were successful because of three components: the reasonable suspicion requirement, the forthwith requirement, and use immunity. She went on to say, quote, in British Columbia in particular, we've eliminated use immunity because we have the immediate roadside prohibition scheme. That's out the window already. Now we're taking away the reasonable suspicion and forthwith requirements and making it simply make people blow or make people participate in these invasive testing procedures, quote. Ms. Lee also advised us in her brief, quote, there is no other instance in the criminal code that authorizes a search based on no articulable or legal standard. There is no other instance in Canadian law in which such a search has been held to be reasonable, quote. In the landmark case of R versus Oakes from 1986, the Supreme Court of Canada established criteria for determining whether a law that infringes on the Charter should be upheld as a reasonable limit under Section 1. That test, of course known as the Oakes test, requires the law to have a sufficiently important objective, a rational connection to that objective, be minimally impairing, or extend no further than is necessary to achieve that objective, and for there to be proportion between the infringement and the benefit of the law. Legal witnesses testified that the random alcohol testing provisions of Bill C-46 would neither be minimally impairing nor proportional under that evaluation. A number of witnesses alerted us to an increased risk of racial profiling under a random alcohol testing regime. Professor Stewart said, quote, so what's the worry about taking out reasonable suspicion? The worry is undoubtedly racial profiling and the police force against racialized groups, Indigenous people and vulnerable groups. I'm always a bit reluctant to state that. I was a prosecutor. I've worked with police officers. Are all police officers racist? Of course not. And many times when you assert that, they're very upset. But there's no doubt at all with the empirical data we've had in Toronto, Vancouver, Saskatchewan, and elsewhere that investigative detention under the practice of carding has resulted in huge racial discrimination against vulnerable groups. Professor Stewart then went on to say that the potential for abuse of mandatory checks is, quote, exactly why the Supreme Court of Canada has put in place a standard of reasonable suspicion, quote. Another major concern is the impact that an avalanche of charter challenges will have on an already burdened court system in this country. Cases of impaired driving comprise one of the biggest gluts on our criminal court system, and that system is already overstretched to the point where it is breaking. For me, the Supreme Court of Canada's Jordan decision was a game changer. The decision, which established strict timelines by which court cases must be resolved or thrown out, has created a stark new reality where serious criminal charges, including charges of murder, sexual assault, and child assault, are being stayed because of extreme court delays. The charter rights infringement of random alcohol testing will only exacerbate this crisis. Most senators who have been members of the legal committee could tell you that I'm generally pretty tough on crime. That's why I don't want to see murderers and rapists go free because of court delays based on unconstitutional legislation, while law-abiding Canadians are potentially treated like criminals by the state. I thought it was interesting to hear the Justice Minister call our committee amendment to delete the random alcohol testing provisions irresponsible. I submit instead that it is irresponsible for this Justice Minister to be acutely aware of the court delay crisis in this country and to fail to take even the most basic actions like appointing more judges in order to address it. The Justice Minister's lack of action on court delays has been abysmal. Our legal committee put out an extensive report on court delays a year ago, the culmination of an intensive 18-month study, and the Justice Minister has largely ignored our recommendations. We recently heard from one of her officials that the minister still has 59 judicial vacancies to fill. This Trudeau government's priorities are all about politics, not about policy. A number of the measures in Bill C-46, which will actually prove effective for fighting impaired driving, were introduced in Conservative government legislation in 2015. The Liberals could have implemented those changes 2.5 years ago. Think about how many lives could have been saved by that. Instead, the Liberals introduced Bill C-46 in order to provide themselves cover for legalizing marijuana because they know that we will see an increase in impaired cases after legalization is passed. We have seen similar results in jurisdictions where marijuana has already been legalized. I had asked the Justice Minister to explain why it is that drugs and alcohol are treated differently under Bill C-46. Police need a reasonable suspicion to pull over a driver and administer a drug screening test, but not for a breathalyzer for alcohol. When I asked the minister to explain the discrepancy, she responded that the science for testing drug impairment was still evolving. Minister speak for just not ready. This begs the question, if that's the case, then why legalize marijuana now? As senators, our role is always to provide sober second thought on legislation. That is what we have done in our legal committee by voting to remove this unconstitutional measure from Bill C-46. Make no mistake, random alcohol testing would lead to charter rights violations, endless legal wrangling, and significant court delays. Our courts are in crisis, honourable senators. We cannot burden them further with clearly unconstitutional legislation. The consequences are simply too dire. Thank you.
Senator Gold, do you ask a question?
Question, Senator Batters.
Senator Batters, would you take a question?
Yes, I will.
Senator Gold.
Thank you, Your Honour. Thank you, Senator Batters, for that. As you know, I happen to think that the legislation in mandatory alcohol screening is, in fact, constitutional, but I'll save that for third reading debate. You mentioned that we heard from a large number, which we did, of experienced criminal lawyers, spoke of the witnesses that came before us, but properly reminded us that we did not hear or have the benefit of questioning either Professor Peter Hogg, the noted constitutional scholar, or Professor Solomon and Dean Chamberlain, both experts in impaired driving law. So can you explain or comment on why, over the course of months of study and 13 meetings, We weren't able to accommodate those, all of whom spoke in favor of the constitutionality of the bill, but we were able, literally on the day that we went clause by clause, to find time for Professor Don Stewart, a leading criminal law expert, to be sure. Thank you.
Well, I'm not on the steering committee on legal anymore, so I'm not sure of the ins and outs of that, but I know that considerable effort was made to try to accommodate the witnesses that you speak of, and I addressed Professor Hogg's remarks that he made in his brief, which he provided to the House of Commons, and then it was just forwarded along to our committee, not updated, but just simply the brief that he provided to the House of Commons, as well as I dealt with how two significant witnesses, Professor Stewart and lawyer Kyla Lee, dealt with his particular arguments. So, and in that, I also appreciate the fact that you acknowledge that Professor Stewart is a leading expert in the area of criminal law and charter reform.
Senator Gold?
Thank you. Indeed he is. I think a whole generation of lawyers in this country learned their criminal law from his readings and writings. I have enormous respect for him, though you may not be surprised to hear that I found his testimony, which I somewhat less helpful than it has been made out to be. But you did quote him, and it's a fantastic soundbite. And it happens to be true that the Supreme Court has never upheld a Section 8 violation under Section 1. But you did not remind us, so I'd ask you if you could comment on the following, that in fact Professor Hoggs, Professor Chamberlain, Professor Solomon all argued that in fact there would be no violation of Section 8 under mandatory alcohol screening. But my question is this: can you comment on how many Section 8 cases the Supreme Court has decided where Section 1 was actually at issue? Thank you.
I don't have that information at hand. However, what I do know is that Professor Stewart, when directly asked about that, I think it was actually in his opening remarks, that the Supreme Court of Canada, in 35 years of charter jurisprudence, has never held a Section 8 case to be saved by Section 1. And in relation to the other questions that you raised, certainly Professor Hogg has one position on this particular legislation. Other noted experts have a different position. I don't know what the ins and outs were of which particular witnesses came to our committee. I just know that the ones that did come to our committee, where we had the chance to question and challenge their testimony, I thought that they effectively refuted Professor Hogg's arguments. You may disagree. That can be a matter, I guess, for debate at third reading.
Senator Gold?
Thank you for your indulgence, Your Honor. Well, indeed, Senator Batters, I mean, I think one cannot read the evidence before the committee without acknowledging that there are very strong, powerful arguments on both sides by credible lawyers, members of the defense bar, members of the civil liberties bar, and notable academics in all their fields. Senator, this is the fourth time I called Professor Stewart Senator.
Senator.
My question is simply this. Would you agree with Professor Stewart when he says with disapproval that over time, since the Oakes case, the Supreme Court has changed its approach to Section 1 of the Charter and is showing increasing deference to legislative choices, and cites also with disapproval, and perhaps you could tell me whether you agree or not, he cites with disapproval the following statement of the court, and I'd appreciate your comments on that. When the Supreme Court said, if legislation is amenable to two interpretations, a court should choose that interpretation that upholds the legislation as constitutional. Thus, courts must presume that Parliament intended to enact constitutional legislation.
Ms. Up, Senator Batters. Senator Boisvenu, on debate.
Alors, merci, Madame la Présidente.
Thank you, Madam Speaker. I'd like to pay tribute to all committee members for the very professional and in-depth work that they did. Senator Joyal also did considerable and very good work on this. Very briefly, it's crucial that we remind you that C-46 is basically a child of C-73, which was tabled in June 2015, by the Conservative government. If that bill had been introduced in January 2016 or December 2015 by the Liberal government, we would not be in this mess today when we're putting the cart before the horse. We know that the report clearly showed police officers will not be ready when marijuana becomes legalized, and that for Canadians, and particularly young people, might lead to huge problems. Police officers are neither equipped nor trained. That can be a very long period until they are. It might take 6 months to a year before they are really in a position to administer the legislation properly. Moreover, that lack of preparation on the part of police officers will hold us up in the courts. There are going to be a lot of legal challenges since the police will be ill-prepared to lay charges. The other part of the study in which I'm so disappointed is how victims are being treated and their families. They testified before the committee and they were stunned to find out that when you drive drunk and you're stopped, you have the same minimum sentence as if you're driving drunk and kill somebody. That's not understandable. For someone who's driving drunk and causes no harm and someone who kills a person to be treated equally, it's absolutely incomprehensible to the victims' families to see that senators can condone the kind of legislation that will let someone who runs down or kills someone else on the road to end up with a $1,000 fine. They are just flabbergasted, given what they experience when they lose a member of the family or a loved one. So I hope that at third reading or at some point amendments will be brought and that there will be a broader and better understanding of what's happening to victims. Put yourself in their place for a moment and watch somebody who ran down a member of your family while drunk get a $1,000 fine. Think how that might feel.
Pardon, sénatrice Dupuis, je vous entends.
Senator Dupuis, I'm afraid I can't hear you. Would Senator Boisvenu agree to take a question? Senator Boisvenu, would you agree to a question? Senator Dupuis. Thank you, Senator. You are talking about victims. I'd like to know whether you know about the letter of May 28th, last week, a letter addressed to senators by Mothers Against Drunk Driving Canada. They represent victims and they believe that the amendment to withdraw random screening for alcohol-impaired driving was a mistake. They think we made a serious error in eliminating random screening. Do you know about the letter? And do you know about the letter that was addressed to us today by the leader of the president of the Canadian Police Chiefs Association, Director Mario Harel, who supports MAD and adds his voice, asking senators to come back on the amendment by the Senate Committee on Legal and Constitutional Affairs to withdraw random testing, to get rid of it. That is a mistake. I'm very uncomfortable about an organization that says that it represents the victims of families killed in road accidents, but who supports legalization marijuana. That organization has been assisted by marijuana organizations, companies. With regard to the police officer's position, I had the impression that we needed to go into this in more detail, but legal experts, constitutional experts who talked to us about it, said that we had to choose one of two problems. Either we stop people with no justification randomly and test them. I'm a police officer, someone's driving, I stop him or her. There was a very clear danger of racial profiling or other profiling, and there would be so many legal challenges that significant matters like rape and murder cases would have been delayed in the courts, as we've seen in recent years, when murderers got back on the streets. So people said, yes, you can do the random test, but you'll end up with courts full of people who will be challenging all the times when somebody was arrested after a random test, because it would be counter the Charter of Rights and Freedoms. So I think we have to protect our courts from this slew of legal challenges, and so that we can speed up the kinds of processes that made us release murderers, because the court cases were taking too long. I was going to just listen to your answer, but I have a great deal of respect for Matt. You said that the organization, which has been around working hard for decades, raising awareness among Canadians about the dangers of being drunk at the wheel. There was even a senator who was the leader of the Conservative caucus who was someone who helped found the organization. What I want to know from Senator Boisvenu is where he gets the comments to the effect that the association is funded by marijuana producers. Two companies, Senator Boisvenu, two companies who in fact have provided MAD with financial assistance. Senator Ranguette, could you please name them and tell us the amounts of these contributions? I will provide the speaker with this information.
It was moved by... Oh, do you have a question?
Senator Boisvenu, will you take a question? As you're well aware from the evidence given at the committee, we lose about 1,000 Canadians a year to impaired driving, and about 60,000 are injured. And there are successive governments have attempted to deal with the matter of impaired driving in this country. We actually rank certainly not in where we should be as a country when you compare it to other developed countries. So I'm interested in terms of work that's been done by previous governments, in particular bills that have been introduced in the other place, and if you can provide me with a reason why this time you think that this aspect of the bill to do with mandatory alcohol differs from that.
Senator Boisvenu.
Madam Speaker, I didn't entirely understand the question. Would the senator mind repeating it?
Keep up with it.
On the matter of impaired driving by alcohol, successive governments have attempted to bring these statistics down. Previous government has attempted to deal with that, both through work of the government, work of committees in the other place, as well as a private member's bill. So my question really is, why at this point would you take a position that you are against mandatory alcohol?
Senator Boisvenu.
Madame la Présidente,
Madam Speaker, this is the era of digitization. The companies are Tweed and Bedrocan. They were funded over 3 years. As I said earlier, when the committee began studying C-45, I thought all drivers should be tested, not only those who were perhaps drinking, but we should test them for cannabis as well. You say that the bill is discriminatory, so we would be doing random testing for alcohol but not marijuana. That was discriminatory. When I heard expert testimony on this, the experts said almost unanimously that random testing would fail the Canadian Charter of Rights and Freedoms test. When you were in opposition, particularly Liberals, we heard that kind of argument all the time. That's anti-constitutional. Some of our bills, some of our statutes were challenged and we lost. So I had the same kind of reasoning. When I hear reasoning and arguments that convince me that something is anti-constitutional, that we're going to have a slew of challenges before the courts. What we're going to end up having is lawyers arguing constitutionality in court. That's not going to help us advance the law, and that's not going to help us when courts are so clogged up they can't deal with more serious cases. So I felt logically we should focus on sound legal footing.
It was moved by the Honourable Senator Joyal, seconded by the Honourable Senator Day, that the report now be adopted. Is it your pleasure, Honourable Senators, to adopt the motion? On division, when shall this bill be read a third time? Senator Boniface.
Honourable Senators, I move that the bill as amended be placed on the orders of the day for third reading at the next sitting.
It is moved by the Honourable Senator Boniface, seconded by the Senator Joyal, that this bill, as amended, be placed on the orders of the day for third reading at the next sitting of the Senate. Is it your pleasure, Honourable Senators, to adopt the motion?